This station
Speaking of miracles, we got a show to do.
by the station of the products or services discussed in the program. The station does not guarantee the results of any investment.
You got a case of the week today, or
Yes, please.
The Word on Wealth.
Okay.
Gary Quackenbush is sponsored by the Word on Wealth Radio Network.
The Word on Wealth.
This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now,
live.
And that very thing we are here to do today is preserve your family's financial future. Moving money from you to your loved ones, wealth transfer, that's a big deal because when you die, everything you have will be subject to that. So whether you have a little or a lot, it's absolutely everything. And we are here. My firm, my world is created to help people have a smooth transition of their wealth to their loved ones, whether that's their children or their cousins or nephews or nieces. It doesn't matter. We are working with people to set up estate plans. I usually might start out when I explain to people like, hey, here's how an estate plan works. Usually we are thinking in terms of an estate plan is for people that have died. And that's kind of the typical thought that, oh, it only has to do with dead people, but it does not. It has to do with people that also are alive and people that are alive, but incapacitated, like mentally incompetent, financially incompetent, so that not just bad money manager people. I don't mean that. I mean somebody that is basically declared incompetent, mentally incompetent. And then it would be that their estate plan would cover all of those situations so that they could still have access to their money, access to their care, and be able to, use their hard-earned money to now take care of them, for them to be comfortable for the rest of their life. So estate planning, I have a seminar that I do, and I call it estate planning cradle to grave. And that's literally what we're trying to do. Most people are just thinking about, okay, when I die, this is what's going to happen. Okay, that's fine. But there's a lot of other issues in between, and we deal with those right here on this show. So welcome to the Word on Wealth. I would love to have you participating today and asking me questions. We've had some great calls in the last couple of days coming in. I'd love to have that again today. 888-344-1170 is the number to call and ask me your estate planning questions. 888-344-1170. Let's have you ask me the question, and you can be part of the show, and I will answer the best I can. And you get it right here today, 888-344-1170. Okay, so I had some questions that were posed to me, and I want to go through them. I think this is, for me, it's easier for people to ask me questions because then I know the topics that people are interested in. So I'm going to go through some questions that were asked of me. And if you have questions, like I said, call, and we have lines open waiting for you to call. All right, so the question was, using an adult child as the trustee of a living trust, good idea or bad? The things to consider in my answer, the things to consider is, what if you did name your children to take care of, to be your successor trustee, and you got into a condition where maybe you were incapacitated and you have this really stingy child that's thinking in terms of, this will be my money eventually. And so I don't want to spend so much money on mom and dad because it's kind of bleeding off the estate. And so I think we should put them in some place that's just, that just isn't as nice. I don't think we should worry about super comfortable. I think we should just worry about adequate. So do you want a kid that's going to be stingy, thinking that basically you are spending your inheritance on your care and that they care about that? And I would say you do not want a stingy child managing your money. You want a child that's generous, the one that says, it's mom and dad's money. If we have to spend every last penny taking care of them, we're going to budget it so that they get good care and they're comfortable for the rest of their lives. So that's the one you want. You don't want the one that's a pushover that, would, kind of give up and say, mom and dad are incapacitated, I'm taking care of their money. We've got them in a facility. So how much money do you need to take care of your family, other families and stuff like that? You want a trustee that's going to be honest, do what you want them to do. And if you can't find one, if you have kids that you just think, no, they're not going to be good at this, they're not going to do a good job, they're going to be we got too many things going on, and I think they're going to be kind of ignore me or not do a good job managing, then option is a professional fiduciary. Now, what I typically recommend, there are a lot of people that actually are professional fiduciaries. There's some that are licensed to be an actual legal professional fiduciary in California. You have to be a registered professional fiduciary. You have to have classes, you have to have a license, bond, so that you can do it. And you don't want to get just at any Joe off the street and say, hey, be my fiduciary. Even if it's like your tax professional or a financial professional, if they are a registered fiduciary, they can do it. If not, they're not supposed to touch it. So a professional fiduciary, there's an organization in San Diego called the Professional Fiduciary Association of California, PFAC or PFAC. And PFAC is an organization where there's people have membership. And if you have membership, they allow you to be a member of PFAC if you have the fiduciary designation, if you have insurance, if you have a good reputation. So sometimes going through an organization like that to find a fiduciary is a good idea. And that's, we help people with that. If you can't find somebody, let's look in the PFAC directory, find somebody, you can interview them, see if they want to do it and put them in as your fiduciary. So that's a possibility too. Really, the bottom line is choosing a trustee. Think of the name, think of the term trustee. Okay. You need to have somebody that you can trust. And if you do, if you have somebody that, a child that would be generous with their spending to take care of you, or that, and you'd be taken care of, then yes, name your children, name a child. I wouldn't do multiples. You could, but I would not do I don't like co-trustees. There's some circumstances where I can put up with it and I appreciate it, but for the most part, I want one person in charge, and the rest of them get to see it through the accountings and through the responsibility and the fiduciary, accountability that fiduciary successor trustee has. Okay. That was the answer to one question. The next question was, Gary, what's the best way to turn over my small business to my kids at my death? Really, the big thing with turning your business over to your kids, I think, is whether they want to run the business. And I'm a big fan of if you think you want to turn your business over to your kids, get them involved now, whether it's, on a part-time basis, on a very, very limited basis, or on a full-time basis, get them involved now so they know how to run it, so that when you do become incapacitated and when you do pass away, that they'd be able to manage. And then that would be the kid maybe that you would give them a percentage or all the shares or, of that company, so they can continue to run it as part of their inheritance, as part of the nest egg. Maybe it's a husband has a business and he wants to turn it over to his kid that's helping him in the business, as long as that child keeps mom on payroll to take care of her. But the, other possible options are available is like one, besides getting them involved ahead of time, is either incorporate or have your business set up as a limited liability company. And that way the limited liability company or the corporation can be part of your estate plan. So that way that child that's inheriting the business or a percentage of the business can get that, like a turnkey inheritance, when it's the stock or the membership interest of the LLC, that is what's passed to them through the living trust. That authorizes them to get into bank accounts and manage the company, and if they need to sell it, or if they want to run it. So I think entities are a big thing. If you want a free book on how that works, on what entities look like an LLC compared to a corporation, my website, gqlaw.com has a free book called Accidentally Self-Employed. It's free. Go to the website, gqlaw.com. You click on the book cover that says Accidentally Self-Employed, and it talks about LLCs and corporations. It says that on the book cover. It's an ebook. It'll get sent to you in a PDF. We'll be back in a second. I want you to take your calls. We have lines open at 888-344-1170. We'll be back here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com. You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, you law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do audit reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQLaw.com, 855-500-TRUST. GQLaw.com.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
It is now time for Gary Quackenbush and GQ Law. Case of the week.
All right. Thank you, Noah, for that wonderful introduction. All right. This is the son, let's see, actual case. Son had trouble with money, but capable of taking care of his own basic needs. The parents provided a lot of support physically, financially, emotionally, but they want to leave him money to use for the rest of his life. Okay. The problem was this particular son, if he inherited money, then he would no longer qualify for his Medi-Cal benefits. So he was getting Medi-Cal, which is based on income levels. If you qualify for it, you can't have more than $35 a month income. You can't have more than $2,000 in assets. So basically, the boy had no money, but he qualified for Medi-Cal, and he was, taking care of life and had just enough money. So if he then if he inherited money from his parents, and obviously if it were more than $2,000, then his Medi-Cal benefits would go away. He would no longer qualify, and he would not receive them until he spent down whatever money he received. Then he would reapply and see if he could qualify again for his Medi-Cal benefits. Solution. This is an easy one, and it should be a no-brainer, but not a lot of people know about it, and that is a special needs trust. A special needs trust, in this particular case, they set it up to where the older sister, who was very endeared to her brother, was happy to, watch out for him. She'd been doing it her whole life. So now she is the successor trustee. And when their parents pass away, she will become the successor trustee of the special needs trust. Special needs trusts are really cool. If you have questions on this, I can work you through special needs trusts. We can handle all that kind of stuff. And the nice thing is, if you want to learn about it, I'm happy to teach you. I just have you come in and we'll tell you how they work. My number is 855-500-TRUST, 855-500-TRUST. Okay. The other thing in this was sister was, there was an alternate provision in that special needs trust that said if sister could not be the successor trustee for any reason, she just resigned because she couldn't deal with it anymore. She was too busy. She lived in another country or another state, or was, incapacitated or deceased. Then the alternate was a professional fiduciary. We talked about that a little bit at the beginning of the show. Is you can get a private professional fiduciary to manage even special needs trusts. So the idea really is you have son and daughter. Son is special needs beneficiary. You don't want to say, okay, we're going to leave no money to son and give all of it to daughter and she can take care of him as she will. That's really difficult, challenging, and I think unfair to daughter. So what you would do is you'd say half to daughter, half to son, but the money that was going to son gets put directly to a special needs trust for son's benefit, and it is managed by sister, who then can later turn it over to somebody else because there's an alternate there, and that would be a private professional fiduciary. So special needs trusts are really cool. They're really, I think, a great benefit. Another way that we've used special needs trusts, which I really thought was clever, not just because, it's not because I thought of the original idea, but the special needs trust where we put in some provisions, some terminology, some wording in there where it made it so that the beneficiary didn't have to be like completely incapacitated, just like financially incompetent, if you will. So it made it so that we put the money into the special needs trust and the beneficiary was just terrible with money, but the special needs trust allowed that successor trustee could provide a budget, even though it would make it so that he didn't qualify for Medi-Cal. In this other scenario, he didn't get Medi-Cal because he had a job. He had an okay job. He was making okay money, but the parents wanted to leave him money that they were afraid that he would just spend like crazy and then be out of money in 6 months. So we set up a special needs trust for that son. We had the successor trustee of the trust, who originally was one of the brothers of the parents. So it would be an uncle. Then there'd be an aunt that was next, and then it would be a private professional fiduciary. So we set it up that way. So what happened then, when parents passed away, then the uncle and the aunt are the ones that were taken over as successor trustees to be the special needs trustee. And then they would make determination of how much money they need. The thing is, what happens is sometimes by the time the parents get around to passing away, then the needs are different. So in this particular case, he still was bad with money, but it was really kind of costly to have the successor trustee getting his budget, determining what he needs, paying things on his behalf. So they decided that he was capable enough to manage money, but not all at once. So they went and bought an annuity. Now, I thought it was a brilliant idea. It may not be the only solution. You may have some other solution, but it was brilliant. They bought an annuity that paid him like $7,500 a month, which is more money than he'd ever had in his life, but it would pay him that for the rest of his life. So I thought that was an appropriate use of it. I think that was something that the successor trustee made a good judgment call on, and they did it, and they didn't have to worry about him. He always had money. If he blew it all in 1 month, then the next month he'd have more. So that would give him the chance to live better, live in a nice place, take care of himself, have some fun. And then the trustee would not be drawing fees every, annually or monthly to do the trust management. But then they really didn't have to worry about it. Just bought an annuity, put it in the son's name, and they had made the determination that he was going to be okay. He could manage the money enough. There may be some waste and maybe some learning experiences, but that was good. So I thought that was a great solution. So that's like a special needs trust alternate. We're using some of the special needs trust provisions to control the money, but giving the fiduciary the successor trustee some latitude, some flexibility to go ahead and give it to the special needs child if if it was warranted, and it was. Okay. So I have so many more questions to answer. One thing that did come up was, and I would say this comes up a lot, is what about how do you buy a house from the trust? And some people think it's hard. Some people think it's easy. I think it's a royal pain in the neck if there's a bunch of beneficiaries. So the way you're doing this is if there's enough money in the trust, like let's say, for example, you have a house that's worth $500,000 and there's $2 million. I know it's a lot. Let's say there's $1.5 million cash and $500,000 house. So you've got $2 million of estate property, and you've got 2 beneficiaries. So that's an easy one. If one of the beneficiaries says, I want that house, and the other one agrees, then instead of dividing the house in half and dividing the cash in half, $750,000 to each, the one that wanted the house received that title to the house, and that was $500,000 of value of his inherited share. Then the rest would be another $500,000, so he would get his $1 million. It's going to be partly in cash, which is the $500,000, and partly in kind, which is the actual piece of property, because they came to an agreement it was worth $500,000. And now the daughter gets her $1 million. So that's pretty straightforward, just taking the distribution. What if, however, you have a situation where there are 5 children and there's a house worth $500,000. One of the kids wants to buy the house from the trust, but there's really not much other money. There's another $50,000 that really we're going to need to kind of work through the distribution and work through the house sale and stuff. So you're effectively looking at an estate that has just a house in it. Each of the beneficiaries are entitled to 1/5 of that house, which is about $100,000 in value. But you have one beneficiary that really, really wants to buy the house. If you borrow money on a house, like typically, they will loan you the money, but they put the money in escrow, they put the deed in escrow, and they put a trust deed in escrow. And it's all signed at the same time. And until all the documents are signed and the escrow company says, yep, thumbs up, everything is perfect, that's when the escrow instructions and contracts are all signed and they transfer over to the, to where they need to go. And then the money transfers over to the seller. Okay. So all those transactions or the borrower. So all those transactions have to happen at the same time. Now, when the trust owns the house and it's worth, in this case, $500,000, if one of the kids wants to buy it, what value do they have? They technically own about a 1/5 interest. So 20, so in this case, it would be, 1/5 would be about $100,000. So technically that child would need to buy that house from the estate for $400,000. Where does he get the money? He's got to go to a bank, and the bank's going to say, okay, brother, we'll be happy to loan you the $400,000. How are you going to pay for it? And he provides his bank statements and his, all these things. And the company says, okay, great. It looks like we could loan you $400,000. What are you going to give it? What are you going to use for collateral to secure the loan? Well, I have a house. No, you don't. The trust has a house and you're entitled to inherit 1/5 of it. So that house is not available for the lender to put a lien on. They can't get their regular trust deed on the property. So what's going to have to happen is the lender needs to do 2 different loans. One is they're actually loaning money to the borrower beneficiary, and they're loaning him money against his
2 minutes.
Inherited share. Okay. So they're going to put a lien on the house. They got to get permission from the beneficiaries, permission from the trustee, and they're basically loaning him money based on the promise that he's going to inherit from the estate, and they know how much the house is worth and all that stuff. So it happens, they get $400,000. He probably has to put up collateral and something else because that's really not a lot down. That's about 20%. It should be enough. And then after he borrows the money, Then the trustee finishes their job, does the distributions to everybody. They each get their, their money that was in escrow from the loan. They each get their $100,000. And then the remaining sibling, the one that bought the house, gets the title. So he had to put $400,000 in the estate to pay his siblings, and then he gets title to the house with his credit for the $100,000 share that he was entitled to. Okay, now the lender says, okay, now you got to refinance because those loans are really expensive. Okay, they had to pay a huge big percentage, I mean, way higher than market rate, but they did it. They pulled it off, and the second loan later gets refinanced. And there's rules like you can't do it immediately. They had to be like 90 days later. So he had to pay high interest for a while and the insurance and all that stuff. So it is possible. It's not easy, but it is possible. If that's something that if you're working through an estate, you want to buy a house from your parents' estate, buy it off your brothers and sisters, or out of the estate, then let me know and I can help you walk through that process and also refer you to a mortgage company that would help you with that. You can call me at 855-500-TRUST and I'd help you out. 855-500-TRUST. I'll help you with your estate plan. I'll help you with ideas. I'll put together your living trust for you. Give me a call, 855-500-TRUST, and get your free consultation. This is Gary Quackenbush on the Word on Wealth. We're going to take a really short break. When we come back, I want your calls. I want your questions, 888-344-1170 here on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST. You're not alone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500-TRUST.
Right. Welcome to the Word on Wealth. It's always so good to have you along. Hey, I want to make sure that you know that you can call into the show. I'd love to hear from you, 888-344-1170. Please ask me your questions. If you have a question about how to set up a living trust, why should you have a will if you have a living trust, how do I set up a guardianship, a conservatorship, what are options for, how, whatever your questions are with estate planning. I get them every day. I'm meeting with people every day of the week, Monday through Thursday. We're doing interviews. We're doing a lot of our, talking to a lot of our listeners, and I would love to hear from you on the air so we can answer more questions and get it broadcasted on what the answer to your question is. You can use a fake name if you want, but everything we talk about I'll be on the up and up with you. I am a California attorney and I can help you out. I'm not going to give you legal advice, but I will be able to talk and answer your questions. So please call 888-344-1170. We've got lines open right now, 888-344-1170. Looking forward to your call. Serving as co-trustees. I always say that I don't like co-trustees, and so many people ask me to say, well, Gary, I don't understand why don't you like co-trustees? What is the big problem? Okay, so here's what happens. Let's do this. Okay, so we have a situation where there's a mom and dad and they had a revocable trust. They had 4 kids. Mom and dad really wanted all their kids to carry the load of being the successor trustee. Okay, that sounds fair, right? So they named their kids as co-trustees. Now, I didn't do this trust. This is one that we did the administration on later. All 4 kids were named as co-successor trustees. And there's language in there that says, the co-trustees are to work together. And if one of the co-trustees passes away or can't do it, then there's somebody else in line. So they always wanted all the kids to do it. Well, it is possible that the kids could say, you know what, I don't feel like doing it. You go ahead and do it, big brother, big sister, whatever, and resign. But it almost never happens. And I know a lot of parents will think that, well, I'll just name all 4 of my kids and they can decide who does it. Well, I have never seen that happen, because it is always the situation always is the kids are looking at it going, well, if mom and dad wanted all 4 of us to be co-trustees, there must be something they wanted us to know about my other siblings, or maybe they didn't trust my other siblings, or maybe they didn't trust me, or maybe this or maybe that. So most people want to all 4 of them stay in. So what was happening is, in this situation, we had a kid in San Diego, a kid in Los Angeles, a kid in St. George, Utah, and a kid in Las Vegas, Nevada. Fine. They all wanted to serve together. They care about each other. They know about it. They together at family reunions, etc. Problem. Number 1 is, when we do a trust estate, you have to get a tax ID number. To get the tax ID number, there's a form called an SS4, and that form needs to be signed. Sure, I know some of you are saying, oh, Gary, you can just go online to the IRS website and you can apply for a tax identification number. Sure. And you have to sign something acknowledging, under the penalty of perjury, that you are the sole person that has the authority to get this tax ID number. And if there's 4 of you, that's actually a lie, because if there's 4 of you as co-trustees, you have to 4 do it together. I know. All right. And I will tell you how you're going to figure out that that's really true is you need to go to the bank. Okay. Once you do an EIN. So what I do is I just have you guys all 4 sign the SS4 form. And then I go online with authority from all 4 of you and I do the work for you. Okay. Number 2 is the bank signature card. So they all 4 are trustees. They all 4 have to go to the bank, and banks do not let you take the signature card and hand it to your brother or sister. They want to see that you're there. They also don't want you to come in to the bank independently, one at a time, and show up and say, okay, I'm here, I'm going to sign it, I'm person number 3. The banks that I've been dealing with, and call me if you found a bank that will do differently, 888-344-1170. I would love to know on air what other banks, the way they do it. But the big banks that I know of, they wanted all 4 successor trustees in the bank together: San Diego, Los Angeles, St. George, and Las Vegas. So the kids would get together periodically every quarter and say, now what do we need to do? And they went into the bank together all at the same time, sat there for about an hour and a half, and got a bank account opened. The probate court, sometimes you need probate court jurisdiction, or there's some documents have to be distributed and the trustees need to sign them. Well, it's not impossible. It's just a hassle. And if you think that your kids are going to decide amongst them who's going to handle it, they won't. They'll all 4 try to handle it. And it's difficult enough to be a successor trustee on your own. And when you are, the other ones keep watch. Okay, so I propose a better solution for this particular situation is the 4 kids get listed in some order of responsibility, order of age, order of height, order of, relative, closeness to the family home or the furthest away or whatever. But you come up with some reason or not to list them in whatever order. Understanding that when somebody acts as a successor trustee, they are required to account to the beneficiaries, which would be all the other kids, the other ones that are not successor trustees. So they're going to know what's going on. So you're going to have 1 kid doing the work and 3 kids watching and making sure it gets done right. So it's not like things really get, taken away. But it's not, I mean, I do see people that, the 1 kid is the successor trustee and the other 3 are just like, oh, whatever, I think they'll take care of it. And 3 years later, they go, hey, wait a minute. How come he has a new car and I don't even have my money yet? So those are problems. We fix those too. But I think the solution is let 1 successor trustee handle it. Okay. And I will say though, this is permission from a client that I had, there were 3 co-trustees. This is a guy and his 2 sisters. And I told him, I said, this is a bad idea. 2 of you should resign. You should let my client, his name is Matt, let Matt deal with it. And they said, nope, we're going to deal with it together, even though they lived in different states. And they just would periodically, they all went to the bank together. They're a bunch of money for investments. They all went to the investment advisor together. They took it as a really good experience. They were really close to each other. They all had kids and, so they took their time. And I think that was the big thing, is that really what happened is the brother took the initiative. He took the lead and got everything set up, talked to the bank, got everything ready, got everything set up the appointment, got everybody to go to the bank together, called the financial advisor, so he was willing to carry the lion's share of the work, but his 2 sisters would go with him for the official, signings and responsibilities and things like that. So it was good. And he told me afterwards, he said, Gary, we did it. We still love each other. We still get together. Nothing has really changed. We have our family time together. We still talk. And he said, it was really a good experience for us. It was a lot of work. And he said, I see how you're saying it was harder. I think it was harder, but it was probably good for us. And we did it. And he said, and you can share that on the air if you want to on your radio show. So I thought it was pretty cool. So go, Matt. Did a great job. Not my Matt. It was another client. And that was pretty cool. So it does work. They understood, or his comment was, they understood that Dad wanted them to do it together, and they were really patient through the legal technicalities, because we had to jump through a bunch of hoops. It wasn't, super smooth sailing. We know what we're doing. We did a good job for them, but they were super patient as far as realizing that we need all 4 signatures. So it's not going to happen tomorrow. We had to circulate documents, and some documents you have to sign and they have to be ink signatures. You can't even do DocuSigns or faxes. Just depends on the institution. It depends on the amount of money, quite frankly. So that's my spiel on co-trustees. Let's see. Another one was, we got the
2 minutes.
small business. Oh yeah. So guardianship of minor children. So this is a question. This was one that actually Noah, my producer, he chimes in once in a while and tells me to speak slower or faster or whatever. But Noah's actually on the board right now and he's running this show. And he asked me, he said, guardianship of minor children. How does it work? What happens if what happens to a child if a parent doesn't come home or their parents don't come home from their date? Okay. So it's kind of a clever question, but it's really morbid, but true. What if the parents don't come home? And it's kind of hard to believe this is actually true, but what happens is if children are left at home with no parents, then when the police are called, they have no choice but to take the children with them, and they become wards of the state of California, and they go to a place. Typically, the place they go is Polinsky Children's Center. And that's the place where if there's foster children or something like that, then that's where the children go. So the children are there. They're held there at Polinsky Children's Center, and that's where they live until somebody goes to court and petitions to be their guardian. Okay, now that seems unbelievable. And I know when Noah was asking me about it, he said, that just seems crazy. I know it does. And it is crazy, but it's the law. So as far as like making sure that your kids have a guardian designated, you've got to have a will that designates guardian, or at a minimum, get a nomination of guardian form. There's one on my website, GQ Law. Go to the tab that says free stuff. GQlaw.com is my website. While you're there, get this nomination of guardian. That is the absolute bare minimum. You really need a will, you really need a trust, but the bare minimum, get your nomination of guardian so your kids don't end up in foster care while somebody's trying to figure out who's going to fight over them. You're listening to The Word on Wealth. We got lines open at 888-344-1170. And we come back from this brief break. I want to hear from you right here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
Here, listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there, filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQlaw.com, 855-500-TRUST, GQlaw.com. Listen to the
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQlaw.com.
You're live.
888-344-1170 is the number. We've got lines open here on The Word on Wealth to take your calls and answer your questions regarding anything to do with estate planning, wills, trust, estate planning. Heck, if you really want to answer a question or me to answer your question about taxes, I can do that. You guys know, be nice to your tax professional. Definitely use a tax professional, but be nice to them. Even though the government, based on the emergency order for flooding in California, has made it so that even San Diego County was, it cracks me up. We had some rain in San Diego County, in case anybody noticed. And it rained and it was nice, and it didn't even overflow my pool or anything like we've had in years past. But San Diego County is one of those counties that was declared a natural disaster area because there's so much rain. I'm sorry, that's just dumb. But because the feds did it, then the state had to conform to it. And now they've given us an extra 30 days to file our tax returns. So instead of it being April 15th, it is now May 15th. For a corporation like LLCs and S corporations, it was April 14th, April 15th. Now it's May 15th. So it's a month later, but don't do that to your tax professional. You don't need the extra 30 days to get your W-2 from your employer or to get your 1099s or to put your stuff together. Just do it like you would as if it were an April deadline. Get it to them now. My tax pro, Greg, oh my gosh, I went and talked to him. I get my video back on here. I went and talked to him today. I said, "How you doing, Craig?" And he's like, "Oh, as good as I can." It's busy. There's a lot of people that are getting really tripped up this year because a lot of the COVID benefits, the COVID breaks, the COVID bonuses, the COVID paybacks, all that stuff that was happening over the last couple of years, and COVID forgivenesses and all that, COVID forbearances, gone. So lest you believe that just because people keep wearing masks and because Fauci had his mask on during the Senate hearings, the State of the Union address, lest you believe that means we're still in the pandemic. It ain't happening. It is over. And all those benefits, that we were just like thrown at to where we were like gagging on them, those things are going away. And according to my tax pro, Craig, he said, unfortunately, Gary, there's going to be a lot of surprise people this tax season because there's a lot of these spiffs and benefits and things that, people are holding their breath and kind of hoping for more, and they're not here. And he said, so it's going to be tough for a lot of people. On that note, if you get into a situation where you owe taxes and you can't pay, and it may be painful to pay them, if you can, just do it. But if you can't pay them, you owe a bunch of money and you're like thinking, oh my gosh, my world is ending. There's no way I'd be able to pay this. Call my office, talk to Rich, 855-500-TRUST, and we can work on maybe setting up a payment plan for you. Sometimes you can get rid of penalties too. If it's your first time, you can get rid of penalties, a bunch of things that can be done. So just got to realize things can be done. Don't not file. If you get your tax return back from your tax preparer and you go, oh my gosh, I owe $10,000 this year. Don't hide and not file. You've got to file. And you're going to have penalties and interest if you don't pay, but you can get payment plans sometimes. That's the kind of stuff we'd be happy to help you with. 855-500-TRUST. Okay, one last thing we want to go over today, and that is probate. So the question posed here is, Dear Gary, we hear a lot about probate. Is it a bad thing? What is probate? Is it awful? So what's so bad about it and how can you prevent it? Okay, so there's a 4-part question. Probate, what is it? Probate is a court procedure where judges and attorneys decide who gets your money. It's long, expensive, and avoidable with a living trust. Simply putting together a living trust and properly funding it, putting your stuff in it like you're supposed to and getting it all done right, that will avoid probate, which means you would avoid judges, attorneys, and a bunch of fees and costs. So I think that's a good idea. So probate, let's see, is it awful? Well, depends on who you are. If you're a beneficiary waiting to get paid, because you need some money, yes, it's awful. If you care about how much money is spent on attorney's fees and court fines and fees and the delay, if you care about that, then yes, it is awful. If, however, the person that passed away was a mess financially, there's a bunch of debts, maybe there's business loans and car loans and all these, maybe there's a lot of debts. Sometimes people have businesses and they really struggle, especially during the pandemic, and they may have a lot of money owed and they die. Well, the cool thing about probate is that every single creditor has to, by a very short deadline, put in a claim, a valid, supported, proved claim into the probate. And if they're late, they're rejected, denied. So I've had cases where somebody had kind of a mess, self-employed, they had credit cards all over the place, they had, vehicle loans, they had inventory loans, tool loans. They had a bunch of money, but they had a bunch of creditors, and it was better, in my opinion, to let it go through probate. So we didn't do a trust. He wanted to do just a will to let his estate go through probate. And what happened is after he died, once the creditor's notification went out to all known creditors, creditors had to put in their claims. So there were claims from all over the place. And what happens is the claim deadline is pretty short. It's 4 months after we filed, and about 60% of the claims were too late. And some of the ones that were on time, they didn't provide proof of the claim. They just put in a claim. The guy owes me $6,600 without proof, without the contract, without the receipts, without anything, and the court disallowed him. So I thought that was really cool. So sometimes probate is great because it's a court has to make the decision and everything is court ordered. So if there's any tingling going, if there's any entanglements or any issues you think you want a judge to get in order, probate may be the way to go. So the other thing about probate is it awful? Well, when we talk about probate being awful, we're thinking that the probate procedure is awful. Probate court in and of itself is not awful because the probate court has jurisdiction, the power and authority over all things having to do with incapacity or death. So that means guardianships are done in probate court. Conservatorships are done in probate court. Probating wills is done in probate court. And with trusts, we quite often, at least that's the way it ends up in my practice, is we're going to court to get the judge to give us some interpretation. There may be some issue of a particular asset that's not in the trust, and we want the probate court, to put that asset in the trust so we can distribute it. Sometimes we're going to court to ask for a determination of to interpret something that's going on with the trust. Maybe there's some funky language or something we don't understand, or some ABC or AB split that didn't happen at the first death. Other times we're going into court to compel the trustees to do their job. So if the successor trustee, we don't think they're doing their job or they're not doing the accounting, we can go to probate court and have a judge give us an order ordering the trustee to do their job. Or the opposite is sometimes we'll have a beneficiary that's just being a complete difficult person, just not easy to deal with. And so instead of trying to get them to approve of the accounting that we've been doing, we will actually go to probate court and we will petition. We'll file a petition that says, Judge, we'd like you to look at this accounting, all the distributions we're planning on making, and we want you to approve it, give us an order. So that way the successor trustee is handing out money per court order rather than just out of the trust. Out of the trust is always the best way. It's the least expensive way. But when you have a beneficiary that's likes to fight about things or likes to have their big fancy lawyer filing lawsuits all over the place, and they're the most angry lawyer in town, those are the times when you want to kind of push it into the probate court and let the judge calm down the attorney so that the things can be distributed like mom and dad wanted. So probate court is good. The probate process, if you can avoid it, is not good. It's expensive. It's slow. So for example, let's just say somebody passes away and they have a will. The will says specifically, I want this money to go to my 5 kids, and I want, education for this grandchild, and this car goes here and the jewelry goes here. Very well done, specific will. Okay. For any of that to happen, it has to go to probate. So from the date of death until we get an order from the court allowing us to touch anything, it's going to be about usually 6 to 8 weeks. So everything's going to sit. We don't have money to pay rent or pay a mortgage or pay insurance or anything like that, to even pay the water bills. You're not allowed to touch that person's money because they've died. So you're going to have beneficiaries that are coughing up personal monies to try to cover dad and mom's expenses, on the house to keep it going and habitable looking, but they don't have any legal authority to do it until you get the letters from the probate court, the authorization, and that takes a couple of months. So if it were a trust, all we need is a death certificate. So you can get money freed up in about a week. So I love trusts. I do lots of them. If you want me to work on that trust with you, it's 855-500-TRUST, 855-500-TRUST. Coming up tomorrow, we have got Ken Peckus of Ken Peckus Realty. Is going to tell us about the real estate market and the exciting news coming up on what's happening with the real estate market here in San Diego. So I will talk to you guys all tomorrow. I hope you enjoy the rest of your afternoon. This is Gary Quackenbush on the Word of Wealth signing off. Talk to you tomorrow, everybody. Bye-bye.
Tell a friend about the Word on Wealth, featured since 1995. With financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us, the Word on Wealth team of financial experts.
Hey, Gary.
Serve your family. On the
By chance, did
This is General.